start by indicating what I propose dealing with. The first is the question of jurisdiction. The second will be the question of accountability of the executive in relation to the National Assembly. The third, I will illustrate in what respects we contend that the National Assembly has failed in its duty to hold the executive accountable in relation to what we contend are prima facie impeachable offenses by the President. And then the last point is the question of remedy. Whilst I'm on this topic of remedy, it looks like what the Speaker now contends is that we should have gone back to Parliament and raised the issue as the EFF, as well as the UDM and COPE. But as I will demonstrate in the course of my argument, the court should not accept the objection by the Speaker because, in fact, there have been two attempts, both by the EFF as well as the DA, to raise the matter internally. Both those attempts have failed. Could I then start with the first question, which is the jurisdictional basis that we contend this court should assume responsibility for the case? You will recall that in our original application, we had raised exclusive jurisdiction, or in the alternative, direct access. In the first answering affidavit, the Speaker opposed exclusive jurisdiction and also opposed direct access. But when the heads of argument were filed by the Speaker, although exclusive jurisdiction still remained a contentious issue, the question of direct access was expressly conceded. There is now an attempt in the new heads of argument filed by the Speaker to introduce a qualification to the concession about direct access. The court should reject the attempt at introducing the qualification in relation to direct access. The fact of the matter is that in Mr. Mwerane's heads, there was no qualification in relation to the direct access part of the case. It was plainly conceded. So we would submit with respect that if the court does not deal with the matter as one of exclusive jurisdiction, it's not necessary, we would submit, for the court to address the issue of exclusive jurisdiction. It is enough that the court simply finds that this is a matter sufficiently deserving of direct access, and it should take into account that there is in fact no opposition to the question of direct access. In any event, there are clear factors that we have pleaded in our founding papers, and they are expanded upon in the heads of argument why this court should assume a jurisdiction on the basis of direct access. The one is the obvious fact of the public significance of the case. It does not happen often that there is a claim before this court for an investigation towards whether or not the President's conduct is impeachable. The second factor that should be taken into account is that this case, the substratum of the case, has already been decided by this court. It was, in fact, in the Ngcukaitobi judgment that this case first grappled with the underlying factual matrix of the case. And the case, in a sense, is an extension of the jurisdiction of this court from the Ngcukaitobi judgment. And the third point is the urgency of the matter. This court has already held in two judgments before us, first in the Mazibuko versus Sisulu case, as well as in the secret ballot case. It has already held that cases about the question of the propriety of the President's holding of office should be dealt with as a matter of extreme urgency. And the fourth factor is that the case does not engage disputes of fact. The case ultimately crystallizes to issues of law. The entire case put up by the EFF in the founding affidavit has not been disputed by the respondents. The entire factual matrix of the case has not been disputed by the respondents. So there is, in fact, no dispute of fact that should be resolved by the High Court in circumstances where the court might say, we want to hear what the views of the High Court are in relation to the assessment of the facts. And then the last point, of course, is that the question of direct access is no longer opposed by the respondents. So there can be no one complaining of prejudice that this court would sit as a court of first and last instance. Could I then move to the heart of the case. What are the questions before the case on the merits? There are two questions we submit with respect that the court should grapple with. The first relates to the question whether or not Parliament has failed in its obligation, first to scrutinize executive conduct, and upon that scrutiny, determine how to hold the executive accountable in terms of Section 42(3) and Section 55(2) of the Constitution. And the case here engages the head of the executive, the President himself. And as I will demonstrate in the course of my argument, it does not just engage the President in his official capacity as such. The case engages the President both in relation to his personal conduct and in relation to his official conduct. And we will see in the course of my address that what has happened is the collapsing of the two roles, and hence the issue of the conflict of interest arises. And then the second question is a question of remedy. If the court is with us that we are entitled to the declarators that we foreshadow in paragraphs 2 to 4 of our notice of motion, the question is whether it is appropriate that the court should then order the interdict that we seek in paragraphs 5 and 6 of our notice of motion. And the court will recall that the interdict we seek in those paragraphs is an interdict compelling the Speaker to put in place a mechanism, and we've suggested that the nature of that mechanism should be a multi-party subcommittee of Parliament. And we've also suggested what the terms of reference of that multi-party subcommittee of Parliament ought to be. It should consider whether or not the conduct of the President sufficiently shows that there is a prima facie violation of Section 89 of the Constitution, to the extent whether the Parliament must consider whether or not there are grounds for removal. In this court, in the previous case of secret ballot, this court has already used the term impeachment. So, in summary, what we are asking the court to do is to direct Parliament to consider whether or not the conduct of the President is prima facie impeachable. The second, so this second issue that I raise is disputed by the Speaker. The Speaker says it's inappropriate that the court should issue a mandatory interdict. Rather, what the court should do is to remit the matter to the Speaker to decide what to do with these facts. And I'll show to the court that that order is inappropriate in the light of what we know about the President's conduct and in the light of what, in our submission, is a proven inaction on the part of the Speaker. It is wholly inappropriate to remit the matter to the Speaker. It is, in fact, appropriate that the court should direct the Speaker to convene the multi-party committee. Now, why then do we say that there has been a failure by the National Assembly to scrutinize and hold the executive accountable? So we start there with the principles that have been decided in the jurisprudence of this court, which inform the debate as to the scrutinization, as well as, or rather scrutiny, as well as the nature of executive accountability. Four such principles are important for my address. They come from the Nkandla judgment as well as the UDM judgment, the UDM judgment being the secret ballot judgment. So the first principle is that the duty to hold the executive lies with the National Assembly or with Parliament. And it's important to set this out now because one of the arguments that are raised by the Speaker, certainly in the most recent heads of argument, is that it was upon the EFF and parties like the DA in Parliament to raise the proposal for the setting of a multi-party subcommittee. But as the court will recognize from the UDM judgment in paragraph 10, as well as in the Nkandla judgment in paragraph 97, the primary responsibility to hold the executive accountable and to scrutinize executive conduct lies with the National Assembly. It is wholly inappropriate for the National Assembly to, in a sense, push that responsibility sideways and then ask for the opposition parties to assume the responsibility of holding the executive accountable. The duty lies with the National Assembly as a whole. And the Speaker is obviously the chairperson of the National Assembly. So the nature of the misconduct that we are complaining here is misconduct that happens right inside of Parliament. Because, as I will demonstrate, the second grounds of complaints are complaints related to whether or not President Zuma misled Parliament. Once the facts have been established, the prima facie facts have been established, that there is a prima facie case that he probably misled Parliament, there is a duty that has been triggered on the part of the National Assembly to initiate adequate processes to determine the facts in the first instance.
So the 10 minutes is up.
Thank you, Chief Justice. The second principle is that the mechanisms of holding the executive accountable must not only be effective, but they must also... Yes, sir, Justice.
I'll take you to a different point. You'll correct me if I'm wrong. I understand your client's case to be pegged on the existence of a prima facie case of the existence of impeachable offenses.
Yes.
And that here you rely on the Nkandla judgment, if I may call it that way, as well as the Nkandla report. Now, let us try to visualize a situation where we have nothing like that. A situation where, for example, some members of the National Assembly or even whatever other party or person may show an interest in the matter, takes the view that there is a prima facie case of impeachable offenses, but that is denied by the National Assembly, which obviously means that the National Assembly would then not do anything about it because they do not accept that there is such a prima facie case. Who then is to be the arbiter of the existence or otherwise of the prima facie case? Is it the court? If so, is that within, or should it be within the remit of the court to decide that, or to be the arbiter in such a case?
Yes. Justice Madlanga, there are two answers to the question. Firstly, the court should decide this case on its unique facts. And this is the point that I will deal with next. On the current facts, there is no dispute that there is a prima facie impeachable case against the president. We set that out in the founding affidavit. There is not a single line in the answering affidavit that denies it, both in relation to what the president knew when the Nkandla project was taking place, and also in relation to what the president told Parliament, his excuses that he made in Parliament. So if you confine yourselves to the current facts, it is quite clear that the existence of a prima facie case of impeachable conduct on the part of the president is not disputed. This case really is about what should happen in the light of the fact that there is an undisputable impeachable case against the president on a prima facie basis. So the starting point then, Justice Madlanga, to come back to your question, is that if the court confines its focus to the particular facts in this case, then the issue does not arise as to whether or not the judiciary strays into an area that is preserved for the legislature, or whether the judiciary operates outside. There is a principled question, and that arises not in the case brought by the EFF, but in the case brought by the DA. There is a principled argument that arises as to whether or not the current mechanisms in Parliament are sufficient to deal with instances such as this. But I would respectfully submit, Justice Madlanga, that what the court should be concerned with is the present case. It should decide whether or not, on the facts that we know, what we know about President Zuma, what we know Parliament has done in relation to President Zuma, and then decide whether or not what Parliament has done sufficiently meets the constitutional standard. So,
if I were to ask you to answer the case that is not here, your answer would be that the arbiter, where there is a dispute as to the existence of an impeachable offense, the arbiter would be Parliament itself.
Yes, we would submit that in certain circumstances, it's quite clear where Parliament says, well, we don't think that there is a prima facie impeachable offense. Then Parliament must be satisfied that there is a prima facie impeachable offense. And the other point, Justice Madlanga, in fact, I'm glad you've made a follow-up, because the other point is that what we propose doesn't take away from Parliament's responsibility to satisfy itself about the offences, because what we propose, in a sense, is a precursor to the impeachment. What we propose is that there should be an inquiry into whether or not the conduct by President Zuma is itself prima facie impeachable. What we complain about is the inaction despite the Nkandla judgment, and it is the inaction despite the findings in this court in paragraphs 8 and 9 of the judgment by the National Assembly. We say that inaction simply violates the duties that are prescribed to Parliament by section 44.2 and 44.3 and 55.2.
Mr. Ngcukaitobi, the Speaker says because the DA had brought a motion in terms of section 89 of the Constitution, that is the end of the matter. Yes. Is that the correct statement?
No,
is there any obligation of the Speaker to do anything more than that?
Yes, it certainly cannot be the end of the matter to claim that because the DA brought a motion and the motion failed. Because if one looks at section 89 contemplates, firstly, an establishment of the facts. And because section 89 contains these two provisions, one is the president may be removed in circumstances where there is a serious violation of the Constitution, and the second is where he commits misconduct or he's unable to fulfill his functions. But let's just take the first part, which is the infringement of the Constitution. There is a qualification. The Constitution itself says the conduct must be serious. In other words, the violation must be a serious violation of the Constitution. So that contemplates a fact-finding inquiry. And even on the version that they put up, it's quite clear that there was no fact-finding inquiry on the part of the National Assembly when the DA launched its motion of no confidence. And the other answer, Justice Mhlantla, if one looks precisely at the terms of the motion by Mr. Maimane, the terms of the motion by Mr. Maimane were not about establishing the correct set of facts. The terms of the motion were that the president must be voted out on the basis of the judgment. What we are asking for here is that there should be an inquiry into the conduct of the president. So that's simply not an answer. It's a deflection, to be frank. So that simply doesn't answer. Then the second point about Section 89 is that if one looks at Section 89 also deals with misconduct. There is no way that one can ever establish whether misconduct has or has not happened by simply subjecting the entire matter to a vote. I mean, it just makes no sense at all. The only way to establish whether misconduct has taken place or not is a fact-finding inquiry. And the other point, which is why this defense by the Speaker simply should not avail them, they themselves accept that they have the mechanism of establishing the facts through a multi-party subcommittee of Parliament. And they give no explanation why they have not set up the multi-party process. What they say is that it's because you haven't asked for it. But that simply overlooks the duty that exists on Parliament in the light of the facts that we know in this particular case.
Ngcukaitobi, sorry.
Sorry, Justice.
When would that duty, when would
Chair.
that...
Sorry.
Just the last part.
Yes.
In April 2016,
Yes.
the EFF then sent a demand to the Speaker
Yes.
that there should be some
Yes.
inquiry, probably something in line to what you are seeking now.
Yes.
The response from the Speaker was that the President is not a member of the NA, cannot be subjected to these processes, and that you cannot get any external people.
Yes.
And furthermore, he has paid the money.
Yes.
What is your response to that?
Well, Justice Mhlantla, that answers the very complaint of the Speaker. We know from that letter that the EFF did in fact ask for a fact-finding inquiry. It obviously suggested that in order to ensure objectivity, the fact-finding inquiry should be chaired by a judge. The Speaker rejected the proposal outright. It is not as if she said, the idea of getting a judge is a bad idea, but I have a better idea of getting a multi-party process. So where matters stand at the moment, it's quite opportunistic for them to come to the Constitutional Court and say you haven't explored internal remedies, because they know that the EFF has asked for a fact-finding inquiry, which has been refused. And its refusal was not on the basis that it's because you have not asked for a parliamentary inquiry through which we could do a fact-finding process. Its refusal was the most formalistic refusal. And essentially what they said was, what you are asking for is not contemplated within the rules of the National Assembly. What they didn't do, which is what they should have done if they had a proper appreciation of their responsibilities, is to say, we understand the concern that you are raising. The way to deal with it is to set up a multi-party process. There is no such. And we now hear in the pleadings here that actually, no, we might be willing to do a multi-party process. But the fact of the matter is that this internal remedy has been explored and rejected by the Speaker. So Justice Mokgoeng, I don't want to shift to Justice Katrisa Tilwane without your permission. So what? All right, thank you.
Your mic is off.
As I understand your case, the EFF's case, Mr. Ngcukaitobi, is that the National Assembly has an obligation under Section 42(3) and Section 55(2) of the Constitution to scrutinize and oversee and hold to account the national executive and particularly the President. Now, can you, I'd like to understand the words oversee and scrutinize. Is there something more than the usual that must happen that the word scrutinize contemplates?
Yes.
Or that these two sections contemplate?
Yes, there is. Yes, the answer is yes. In paragraph 85 of the Nkandla judgment, what this court found, and that was in relation to what to do with the public protector report. What they said, and we know in that case that there was complete inaction. And what had happened, in fact, there had been all of those subcommittees, but those subcommittees were subsequently set aside by this court. But talking about scrutiny, this is what this court found. I think it was the Chief Justice who wrote the judgment for the court. And then he says, the National Assembly's attitude was that it was not required to act or facilitate compliance with the report, since the public protector cannot prescribe to it what to do and what not to do. And then later on in that passage, they say, those steps, it says, broadly speaking, it is correct. This is correct because scrutinize means subject to scrutiny. And scrutiny implies a careful and thorough examination or a penetrating or searching reflection. The public protector's report relates to executive action or conduct that had to be subjected to scrutiny. So understood. So if we take the first part of section 44.3, which is what does it mean to scrutinize? According to this court, what this means is a thorough examination, a penetrating reflection, a searching reflection. I mean, no one can say on the facts of this case that there has been a thoroughgoing examination of the implications of the president's conduct. No one can say that...
Sorry, Mr. Ngcukaitobi. So then are you then contending that the question and answer process that was put in place was not sufficient to meet the requirement?
Yes, I am suggesting that there has not been a single process followed by Parliament in relation to scrutiny, which is a thoroughgoing examination of the facts. That has not happened at all, including, by the way, and this is the point Justice Mhlantla was pressing me on, including the proposal by Mr. Maimane. That simply did not meet the standard of scrutiny set by this court. The next question that you are asking...
Sorry, so that was the motion brought to remove the president,
yes,
which was brought at 4 o'clock in the afternoon and ended, I think, at 6 o'clock that afternoon.
Yes.
So what, there was debate and a vote,
yes,
but you're saying there was no scrutiny in that process?
Precisely, because there was no thoroughgoing examination of the facts.
But it's not as if the political parties are denied the right to basically, or the entitlement to bring a motion to remove the president. Well, what you are saying, all of the mechanisms are not in place to realize that right.
Precisely. I am suggesting that if one looks, I mean, what the EFF did ask for was scrutiny, proper. It in fact suggested that the scrutiny must be done by a retired judge. That was refused by the Speaker. And that is why that simply is not open for them to come to court and say we haven't explored internal remedies. So to answer the first question, the answer that we propose as the EFF is that there has been no scrutiny of the president's conduct, despite the undisputed existence of a prima facie impeachable on his part. The second point is that What you do with the outcomes of that scrutiny is then to exercise one's obligations of oversight. And this court has already stated in the secret ballot case that one of the mechanisms of exercising oversight is a motion of no confidence under Section 102, as well as impeachment under Section 89. It is impossible for the Speaker or anyone in Parliament to exercise their obligations of holding the executive accountable, including by resorting to removal under Section 89, unless they have done the scrutiny that we've come to ask this court to compel them to do. Thank you. Chief Justice, may I? Oh, yes, there's a Deputy Chief
Mr. Ngcukaitobi. The Speaker says last year, if I recall correctly, or for a certain period, there was a process within the National Assembly in which all the political parties took part to amend or revise the rules of the National Assembly. And she says that, as I understand her case, any of the political parties was free during that process to make suggestions that could cover whatever the applicants in this case may have wanted to see in the rules in relation to Section 89 processes. And she says none of the parties, none of the applicants made any such suggestions. And she says, well, the parties agreed at a certain stage to leave the process uncompleted. I assume on the basis that they would come back and finalize whatever they had not finalized. Now, I am not aware that the applicants deny that, and it may well be that maybe they didn't get a chance to respond to that. What do you say to that?
Deputy Chief Justice, there is probably one answer to that proposition. The case of the EFF does not suggest that they must introduce a new set of rules. The case of the EFF is that they must utilize the existing mechanisms. They have not utilized the existing mechanisms, despite having the authority. If one looks at the latest affidavit filed by the Speaker yesterday, the Speaker herself says that she has adequate mechanisms. What she is unable to answer is why is she not using those mechanisms in the light of what we know today?
So with that answer, am I right to say, therefore, you and the Speaker, that is the EFF and the Speaker, might be very close in the sense that you are saying within the existing rules,
yes,
what you want can be done.
Yes, precisely, Deputy Chief Justice.
And the Speaker doesn't say, at least now, let's leave out what she may or may not have said some time back, doesn't say now she is refusing to have the existing rules utilized. Actually, if I recall correctly, she said in her answering affidavit something to the effect that what the applicants want, they can get through the existing rules of the National Assembly. That's my recollection.
Yes, yes, Deputy Chief Justice, what firstly, on the question of the rules, there is one case that's taking place that's brought by the DA in relation to the adequacy of the mechanisms. We don't oppose that case, but what we say is that it's not necessary for the court to reach a conclusion on that issue to give the EFF the relief that it seeks. The relief of the EFF is a narrow relief. It is based on the mechanisms that currently exist. There we say two things. One, we are entitled to a declaratory order that since this court delivered its judgment in March 2016, you have failed to take action in relation to the existing mechanisms. Second point is, when we tried to ask you to operationalize the mechanisms, you refused. And we were then left with no option but to come to court.
Well, isn't the position that the request that the EFF made to the Speaker had elements or features that fell outside the existing rules?
Well, I would submit, Deputy Chief Justice, that if the Speaker had been acting properly, and in this instance, she simply hasn't, what the EFF wanted, in substance, was that there has to be a thoroughgoing examination of the President's conduct. The Speaker was entitled to say that the process that you are envisaging, which is, we wanted a process that would have a basic charge, a cross-examination, evidence-led. That process should be done through a multi-party process. It is, in fact, Deputy Chief Justice, the last affidavit yesterday, where the Speaker for the first time says to the court that I have no difficulty with a multi-party parliamentary inquiry. And it is in paragraphs 5 and 6 of our notice of motion that we asked for. Now, if that is so, there is really nothing stopping this court from granting the relief that the EFF seeks. If the Speaker's attitude is that what the EFF is asking for can be accommodated within the existing rules, if the Speaker's attitude is that she herself has got no difficulty with the utilization of the existing mechanisms, there really is no reason why this court should not grant the order that we seek. I need to just say one thing more about those proposals that you asked me about. The most interesting part about those proposals is in LT5. If one looks at that draft that's before the Speaker right now, that draft is a replica of precisely the process that we are envisaging, because it envisages a process to determine the existence of a prima facie case of misconduct. Thereafter, a report being placed before Parliament in order for Parliament to decide whether or not the President should be impeached. So on the level of process, it's unclear to us why the Speaker has put up such opposition in circumstances where she does not deny the prima facie impeachable offense against the President, nor does she deny that the rules can in fact accommodate the request.
Well, talking about the existence or presence or absence of a prima facie evidence of impeachable conduct on the part of the President, I would have assumed that in court we have to assume that to be the case and leave it to the National Assembly to deal with that. In other words, shouldn't we assume that that is the case because of the fact that allegations have been made in the affidavits, and we know what was said in what you call the Nkandla judgment. So the rest should be for the National Assembly to decide whether that case is sufficient or not.
Yes, Deputy Chief Justice, that's true. It depends on where we stand in relation to the proposals that I make. Firstly, let me answer the question about the existence of a prima facie case. I accept what you are proposing to me, that the court must assume that there is a prima facie impeachable offense against the President. And the court does not, in fact, even have to assume this, because it's overwhelming on this record. It's in the founding affidavit. It's not denied in the answering affidavit. Even if you apply Plascon Evans, it's quite clear that there is a prima facie impeachable offense. What is most disconcerting here is that the prima facie impeachable offense extends to his own representations in Parliament. President Zuma has told Parliament several times, one, I have a bond. The public protector says, I've looked into this issue of the bond. I can't make sense of it, whether or not it covers the building in Nkandla or it doesn't cover the building in Nkandla. That on its own establishes a necessity to inquire. When the President was asked by the public protector about this bond, what his response was that I want Parliament to inquire into this issue of the bond, not you as the public protector. Second point that we know is that there was a building in his house from 2009 to 2013. What he said in relation to that building, the public protector found that he knew that public funds were being expended to build him a house. And he knew that the expenditure extended beyond the so-called security features. The court found...
Well, I can only say this, Mr. Ngcukaitobi. You don't have to persuade me
Thank you.
that,
Thank you. Thank you, Deputy Chief Justice.
that there may be a case to be dealt with by the National Assembly.
Yes.
But let's go back to the question I asked earlier on. I said, as I understand it, the request you made to the Speaker had features that fell outside the rules, about judges and so on, isn't it?
Yes, Deputy Chief Justice, I mean, I would contest that slightly. I mean, I won't put up a vigorous defense.
Yes.
There is nothing that prohibits the Speaker from appointing a sitting judge, especially on a matter as important as this. So it's not even her defense. Her defense was not that this is in conflict with the rules. Her defense was that we don't have a process similar to the one you are proposing. But that's a different proposition from saying that it conflicts with the rules. In other words, appointing a judge to inquire into the president's conduct on the Prima Facie case would itself be unconstitutional. We would, in fact, even suggest that it might even be a preferable route to undertake, that you have to take someone who is not only independent, but is also perceived to be independent. And what better person could have been if it had not been a sitting, a retired judge? So I would contest to some extent the proposition that what we asked for was unconstitutional. What I would accept is that on the rules, what she could do is to appoint a multi-party committee, but that is not the same as saying she was prohibited from appointing a judge.
Well, you see, my concern is that the EFF didn't, as I understand the papers, didn't go back to her and say, look, all we are asking you, or we will be content with, a process that's in the rules. We are asking you to do nothing more than what's in the rules. I know that you just said maybe 10 minutes ago that when she responded to the EFF's request, she didn't say, I'm not happy with this process, this proposal, but I would be happy to provide you with a multi-party committee and process, in which case, as I understand your case, the EFF would have been happy.
Yes. Well, what we're asking for now in paragraphs 5 and 6 is simply that there has to be an investigation. If that investigation takes place, we've actually proposed a multi-party investigation. In our heads of argument, we even expand on the features of that multi-party investigation. And we even say, in relation to the features of that multi-party investigation, the Speaker, in fact, does not refuse any of the proposals that we make.
I think if I read the answering affidavits and the acting Speaker's affidavit and the written submissions, I think there is no problem with that as far as the Speaker is concerned. But as I understood part of what she was saying was, you people are part of the National Assembly.
Yes.
You people you are part of committees of
Yes.
the National Assembly. You can utilize these processes to achieve what you want.
Yes. Well,
And my concern is on that basis, but also even if that's not the case, if actually there is, in terms of the rules, a process which could have been insisted upon, which could have given you what you want, would it be in the interests of justice to entertain the matter?
Deputy Chief Justice, there is something deeply disturbing about that attitude which is evinced by the Speaker. And it's disturbing at two levels. One is at the level of principle. The obligation to hold the executive accountable is the obligation imposed on the National Assembly. The representative of the National Assembly is the Speaker. So this idea that what they seek to do is to deflect so that they say actually the obligation is that of the opposition parties is constitutionally deeply concerning, because it is the same attitude that characterized the Speaker's conduct in relation to the Public Protector report. It is the same attitude that characterized her conduct in relation to the secret ballot judgment. And it is the same conduct that we see today. both in Nkandla and in the secret ballot, this court was at pains to explain that the primary obligation for executive accountability is in the shoulders of the National Assembly. You are the representative of the National Assembly. The court must repeat the same message for the third time to the Speaker. So it's constitutionally disturbing that the Speaker keeps deflecting attention in relation to her responsibility of holding the executive accountable, notwithstanding the two judgments of this court, which are expansive with references to where the primary responsibility of executive accountability lies. So that's the first problem that is concerning about this attitude taken by the Speaker, that essentially assigns the responsibility sideways and then avoids responsibility at the end of the day. The second problem why this is deeply concerning is a factual one. The DA has already made a proposal that President Zuma must be removed under Section 89. The EFF has also already made a proposal that the President's conduct must be subjected to scrutiny. On neither of those occasions has the Speaker actually done what this court has repeatedly told it to do, which is to take responsibility and initiative in circumstances such as this. So I suggest to you, with respect, Deputy Chief Justice, that this is again another manifestation of this kind of constitutional negligence that characterizes the Speaker's conduct. And it is the third time we are coming with the same issue before the court. And again, it is the third time where the Speaker again misunderstands that the responsibility of holding the executive, the party that she belongs to, accountable, is on her shoulders. So we would respectfully submit that if one is to be consistent jurisprudentially in relation to what the court has found, it's quite clear that as soon as there was prima facie a case of misconduct, and I don't want to persuade you again, Deputy Chief Justice, I know you are persuaded in the point, as soon as there was that evidence, that duty was triggered. The Corruption Watch makes another powerful submission that what the Speaker also overlooks is the duty to confront corruption. And that duty is imposed by Section 7.2 of the Constitution. What this case is about is that you have the head of state taking public funds for personal use. What does the Speaker think should happen?
Mr. Ngcukaitobi, could I just raise two issues with you, please? Accountability is clearly a constitutional value, and it could take various forms. You could have a soft form of accountability, and you could have a more stringent form of accountability. As I understand your argument, one could have a constitutionally mandated form of accountability that is required to be initiated and led by the institution. Yes. On the other hand, you could have a form of accountability that is largely discretionary and incidental. Yes. That may be in the hands of political parties, yes, who may determine whether to put a question or not. Yes. Why are you saying that this case warrants a more stringent form of accountability if that is indeed what you're saying? Yes.
It is indeed, Justice Colopin, what I say. And in fact, in this regard, I would respectfully submit, supported by the findings of the Chief Justice in the UDM case. In paragraph 10, he explains, the Chief Justice, it thus falls on Parliament to oversee the performance of the President and the rest of the Cabinet and hold them accountable for the use of state power and the resources entrusted to them. And sight must never be lost that all constitutional obligations must be performed diligently and without delay. When all the regular checks and balances seem to be ineffective or a serious accountability breach is thought to have occurred, then the citizens' best interest could at times demand a resort to the ultimate accountability mechanisms. Those measures range from being voted out of office by Parliament through a motion of confidence or impeachment. These are crucial accountability-enhancing mechanisms that forever remind the President and Cabinet of the worst repercussions that could be visited upon them for a perceived or actual mismanagement of the people's best interests. So what I say, guided by that passage, Justice Colopin, is that if one looks at what actually has happened here, this is probably one of the most egregious forms of breach of executive power. And it is not enough to say, I'm expecting the EFF to raise a question and answer, or I'm expecting the DA to make a proposal. What this case requires is, in fact, the kind of ultimate accountability ensuring mechanisms that the Chief Justice spoke about.
And just finally, as I understand it, is the decision to establish a multi-party committee not that of the National Assembly rather than that of the Speaker.
Yes, well,
And if that is indeed the case, then would this court not be treading close to violating the separation principle
yes.
by directing that such a committee be established when in fact the mandate of the National Assembly is precisely to consider the establishment of such a committee?
There are two answers to that, Justice Kolopen. The first is that in cases where there is in fact no dispute between us and the Speaker about the propriety of that process, there is no necessity to fear trenching upon separation of powers. Just as in this particular case, Justice Zondo reminded me of a passage from their answering affidavit, which makes it clear that they have no difficulty with it. So there should be no necessity to be concerned by the court on that score. The second part is that whatever the views of the court might be on paragraphs 5 and 6 of our notice of motion, paragraphs 2 to 4 entirely should be granted because that is the declaratory order that we seek, simply explaining what the law is. So that part of the declaratory order typically falls within the mandate of this court. The interdict part of the order, of course, always trenches upon separation of powers, but the overriding factor here is that this is not, in fact, considered to be inappropriate, even by the Speaker herself. What she wants is a most formalistic order that you must tell the EFF and the DA to go back to Parliament and to raise this. But to what end, given what has transpired so far?
I'm sorry. Yes. Help me understand this. As I understand it, and correct me if I'm wrong, as I understand it, each member of Parliament individually has a right to initiate the process in terms of Section 89.
In terms of Section?
89.
Oh, yes.
And if the motion of no confidence or the motion of removing the president by the DA had succeeded, that would have constituted holding the president to account, would it?
Yes, indeed.
Now, help me then understand, how do we get to a point where we say for the process to be attributed to Parliament, it must be initiated by the Speaker and not by any member of Parliament?
Yes. Well, Justice Chapter, we've got to, firstly, the process that we have in mind, which is the process, a precursor to Section 89, the investigative process. I mean, this court has already found, not in a directly applicable case, but in Nkandla, as well as in the secret ballot case, that the obligation of holding the executive accountable resides with the National Assembly, and the Speaker is the chairperson of the National Assembly, and so she must initiate the process.
But we know that the National Assembly can only act through its members.
Yes, that we accept, Justice Chafter, but what we say in this case is that if one looks at the fact that the request has already been made and that request was rejected at the instance of the Speaker, and then if one looks at the nature of the process that we have in mind, that process has already been proposed and refused. The third point, of course, being that what we propose is not disputed by the Speaker.
Help me understand, perhaps I've missed on the facts, the timing relating to the motion by the DA and the request by your client. What is the sequence there?
I must just check the facts. Yes. The letter by the EFF is dated the 5th of April 2016. It is at page 162 to 163. And the request by the DA. I think that's also the same day. I just want to check this. Yes, I'm told that it was also the same day, the 5th of April 2016. In fact, according to the papers, the debate was on the 5th, and the request by the EFF was also on the 5th. So that you will see from pages 32, 33, 34, 35 of the record.
Which came first? I'm still with you, but which one came first?
The request, it must have been the, oh yes. The request by the DA, I'm indebted to my learned friend, is at LT 7, 31 March 2016. The DA made the proposal, and then the EFF on the 5th of April made the proposal. That motion by the DA, although it was made on the 31st, it was debated on the 5th. So that's on the 5th of April 2016. So the sequence is the DA went first and the EFF came after.
Wait a minute. I'm sorry, my brother. The DA's motion was debated first.
No, it was delivered on the 31st. It was then debated on the 5th.
Right.
Yes.
And the process was finalized around some time after, is it 19 minutes after 6 or something?
Yes. It's after 6.
Right.
Between 4 and 6.
When then did the EFF act?
The EFF sent the letter.
In relation to that time?
Yeah, it sent the letter earlier. The problem, it doesn't say what time the letter of the EFF was sent, but it sent it prior to the debate taking place, prior to the 2 o'clock debate, at least finishing at 6.
It would have helped to know the time.
Yes. Well, I will check whether there is a record of the actual email or the record of the actual, because the letter itself doesn't have any. It's at page 162 to 163. It doesn't say what time it was sent, but I can check that, Chief Justice.
Over to you, my brother.
And we know the response came on the 12th of May 2016 by the Speaker refusing the request by the EFF.
Thank you, Chief Justice. See, my difficulty, Mr. Ngcukaitobi, is at what stage would we, in terms of the law, attribute the process initiated by the DA to the National Assembly as a process of the National Assembly? I would assume, had that motion succeeded, the President would have been removed from office by the National Assembly.
Yes. Well, what we have said about that process are 2 things, and I would like the DA to speak on that topic. But what we've said in our papers are 2 things about it. The first, insofar as it was based on Section 89, on a proper construction of Section 89, Section 89 envisages a 2-stage process. The first is a fact-finding process, precisely because there has to be a determination of seriousness, and there has to be a determination of misconduct. So insofar as it was brought prior to that process, what we have suggested is that it was premature. The second thing we have said about that motion is that it does not replace the process that we are envisaging. In fact, the process that we are envisaging is the process that is constitutionally demanded if the executive has, if the Parliament has to play its role of scrutiny prior to holding accountable. So I would submit with respect to Justice Chapter, whether you do attribute that process to the National Assembly or you don't, actually does not answer the case of the EFF before this court, because the case of the EFF before this court is that there has been a failure of the duty to scrutinize, and there's therefore been a failure of the duty to hold to account.
Would that 2-stage approach apply even in situations where there has been judicial findings by the court. For example, that the president has breached the Constitution. Wouldn't that by itself be a serious breach?
So, Justice Shafter, we've explored this topic in some detail. Let me just debate it a little bit before answering the question. You see, there are two ways in which the president could breach the Constitution.
Well, maybe you would want to answer, and then he can decide whether he needs clarification. I think it would help our time. Your time is already up, by the way.
Yes. Thank you,
It
Chief
would
Justice.
help a lot just
Yes.
to answer, and if there is some uncertainty, he will seek clarification.
All right. Thank you, Chief Justice. So, Justice Shafter, so what I submit about this topic, about the two-stage process, whether it would apply in all circumstances, is that it will not apply in all circumstances. But what we would submit is that on the current case, the two-stage process applies. There will be cases where the court has made a clear determinative finding, but it depends on the nature of that finding. If the finding goes to the person of the president as opposed to the office of the president, in those circumstances, we would submit that perhaps the two-stage process could be obviated. But in this case, because there is so much that we don't actually know, and because all we know are tendentious indications of misconduct, then the two-stage process is warranted. So that's the answer, Chief Justice. The debate is in my heads of argument.
Finally, Mr. Ngcukaitobi, can I just clarify that you're not saying the National Assembly has failed to fulfill its obligation to ensure that the president complied with the remedial action of the public protector. You seeking, or you are advancing a failure to discharge fulfillment of a different obligation.
Yes, indeed, okay. Justice Shafter.
I've just got one question for you, Mr. Ngcukaitobi, and the question arises from the structure of Section 89. Now, the theme of the argument has been that there has a prima facie case of impeachable conduct has been established.
Yes.
But if one has regard, if one reads Section 89, it refers to a serious violation of the Constitution, serious misconduct. Now, the prima facie case that you said has been established, is it a case that establishes serious violation or a violation of the Constitution, or is it a case that establishes misconduct or serious misconduct?
Yes, I would submit.
Who must decide on the seriousness of a misconduct? And secondly, who must decide on the serious violation of the Constitution? Because it will seem to me that it's not all violation will give rise to an impeachable conduct. The violation must be serious.
Yes.
Can you help me there, just to clarify?
Yes. So the answer to the first question, which is which of the grounds, we're relying on A and B. We're saying that there is a serious violation of the Constitution, and we've set out what the provisions that we say have been violated. The central provision is Section 89. The President put himself in a position where there was a risk of conflict between his personal interest and his official responsibility. What makes it serious on a prima facie basis, we say it's because he knew that public funds were being utilized for his benefit, and notwithstanding that knowledge, he allowed the public funds to be used for his personal benefit. Both of those establish the prima facie seriousness. The second part, which is serious misconduct, we say it's misconduct falling outside the constitutional framework, but it's misconduct of I think it's called the Members' Ethics Act by the Public Protector. And that involves the question of what he told Parliament. If he misled Parliament which is the finding that the public protector could not find, that would constitute serious misconduct because it's sometimes a criminal offense to mislead Parliament.
And
The second question, who
sorry.
decides? Justice.
Another proposition which you made, you said that there was nothing that prevented the Speaker from appointing a judge to conduct an inquiry.
Yes.
I'm a little bit worried because that seems to be outside the scheme that is envisaged by Section 89, because it will seem to me that the power to remove the President resides in the National Assembly. And now the body that you were suggesting is the body that falls outside what is envisaged by Section 89.
Yes. Justice Sonde, I accept the broad principle. Let me just confine myself to this particular case because my central theme has been that it's all context specific. What we were proposed here on the 5th of April was that there must be a fact-finding process. The question of finding the facts could be done by a judge. That obviously does not mean that the National Assembly should not decide on its own independently whether or not there is a case that is of an impeachable conduct on the part of the President. So the proposal that Mr. Shivambu sent was do a fact-finding inquiry. After the fact-finding inquiry, take your report to the National Assembly. That process is in fact no different to the process envisaged now by the Speaker, which is the fact-finding process must be done by a subcommittee of Parliament, because there is still going to be a second stage where the National Assembly as a whole will decide what to do with the findings. So the reason I submit that it's not unconstitutional to ask a judge to find out what the true facts are, because of course judges are trained in forensics. And thereafter for the National Assembly to say, on the basis of the facts that have been established by the judge, we want to decide whether to exercise our Section 89 obligations. So, but there's a question I haven't answered, Justice, which is who decides. So in relation to who decides whether Section 89 has been violated, it's the National Assembly. The scheme that we are proposing doesn't take away that power. In fact, it reaffirms the power.
Ngcukaitobi, as I understand your case, you were suggesting, well, I mean, you're saying the EFF did make a request to the Speaker to put in place this mechanism.
Yes.
But as I also understand your case, you are saying that there was a duty on her
Yes.
to set this up without even a request being made.
Precisely, yes.
Because she's supposed to be, I mean, she certainly has party political affiliation. She's there by virtue of the majority party. But at the end of the day, she has certain duties, and she must carry out those duties impartially.
Precisely.
Am I right?
Yes,
So
you are right.
even without a request, and the EFF request is somewhat clouded in this judicial commission being set up and the Speaker not having that power.
Yes.
But nothing stopped the Speaker
Yes.
from setting this up on her own. Even after, well, I mean, as I understand it, you say that the duty was triggered immediately after the Nkandla judgment.
Yes.
Am I right? The Speaker had set up 2 ad hoc committees to look into the findings of the public protector.
Yes.
And basically use that to absolve the President. So nothing stopped her, subsequent to the Nkandla judgment, to actually put together this ad hoc committee. And as I understand your case, you're happy for an ad hoc committee, and it need not be a judicial commission of inquiry.
No, precisely, Justice Kathrisa-Tulane. We accept that, in fact, that's what we propose in paragraph 5 and 6 of our notice of motion. And the first proposition is also correct, which is that this was an independent duty that flows from Section 44.3 and Section 55.2. It's been affirmed twice by this court. And it's not clear why the Speaker says she had no such duty. She had to wait for the EFF.
Sorry, would that duty to set up this fact-finding committee be re-triggered after the DA lost the motion?
Yes, it was a permanent duty. It remained for as long as there had been no scrutiny over the President's conduct. It was never discharged just because the majority ran through a proposal. It was simply never discharged because there was a duty of conducting a thoroughgoing search or a proper reflection on the President's conduct. So that duty remained permanent. It still has not been fulfilled even today. Even the Speaker doesn't say that that duty has been discharged at all. I mean, she refers to a number of other irrelevant processes that have taken place, but never a process designed to achieve the goal that we say is the constitutional obligation.
But as I understand the Speaker's supplementary heads of argument, and we'll hear from Mr. Mainechi about that, they don't actually see the need for a trial-like procedure to be put in place. How does the EFF see this? What is the role of this committee? How does it perform its functions?
Yes.
You know, is there cross-examination? Is there evidence-led? Does the President get represented at these proceedings? How do you understand it?
Yes, what we have proposed in our heads of argument is there are certain basic features of this committee. The one is that its job is to conduct a fact-finding inquiry. The second is to allow the President an opportunity to explain himself. And then the third, most importantly, is cross-examination. We are not fixated about whether one calls this a trial-like process or doesn't, because it is ultimately overseen through a political branch of government. They themselves say, we have powers of subpoena. We can subpoena documents, we can subpoena evidence. And we've set out the features of this committee. And the essential features are natural justice and the duty to cross-examine and a proper fact-finding inquiry. If those features are set out in the judgment of this court, that would satisfy the constitutional obligation, because we are not saying the President must be taken to court. The President must account where he should be accounting, in Parliament. The problem today is that the Speaker has simply allowed the President to go scot-free without accounting for what is clearly on anybody's version a prima facie impeachable offense. So I want to just check where we say paragraph 90 of our heads of argument. That is, those are the features we recommend, which even in the supplementary heads of the Speaker, yes, paragraph 89, that's where it starts, the features of the inquiry. Multi-party committee. A mandate is to determine whether the President is guilty of serious misconduct or serious violation, conducted in public, consider relevant documents, and meaningful questioning of witnesses. And it doesn't have to be cross-examination, but witnesses can be questioned. And the President must be allowed an opportunity to come. If he decides not to take the opportunity, but at least he should be allowed to come. And then, once it has completed its process, it must send a report to the National Assembly for further deliberation.
So just on the point about a trial-like process, if one reads Section 89 purposively, that it obviously it contemplates the two-stage process, yes. But the process of the fact-finding inquiry would be trial-like.
Yes, I mean, one could say it would be trial-like, but as long as it is a meaningful inquiry, yes. But as I say, it is not essential for our case that it must be branded like a trial. What is essential is that it must serve the purpose of ensuring that the facts are known. Because as Mr. Badlander reminded me yesterday, in this case there's something that we know, but there's a lot we don't know. Chief Justice, I must answer the question about the time. Someone has sent me this, I don't know who it is, and I can't vouch for its authenticity.
No, give us things that you can vouch for.
Yeah, so I'm told that it's 6:41 p.m. on the 5th of April 2016, and there is a screenshot available. That's the note I've been given, but I'm not taking responsibility for it.
You'll send us an affidavit taking responsibility.
I'll ask my attorney, Chief Justice, to send an affidavit.
Okay, I just want to check if my colleagues have questions. Well, I have questions.
Yes.
Let's look at Section 89, subsection 1. A. The National Assembly by a resolution...
Which subsection, Chief Justice?
1A.
1A, yes.
A National Assembly by a resolution adopted with a supporting vote of at least 2/3 of its members may remove the President from office only on the grounds of A serious violation of the Constitution or the law. Maybe B also applies serious misconduct. Now, when the Constitutional Court says the President has failed to uphold, defend, and respect the Constitution as the supreme law of the land. What should be made of that?
Well,
Does it say that he has violated the Constitution in a serious way, or does it not say that?
Chief Justice, we would say on these facts, it says that he has violated the Constitution in a serious way.
So what is there to investigate?
Well, Chief Justice, there is a question that remains as to what are the circumstances, whether or not those circumstances...
No. I'm sorry, I'm going to be interrupting you, but
Yes.
you know how we engage.
Yes, that's
And I mean not to embarrass, but just to satisfy myself
Yes.
that we do the right thing.
Yes.
That's what it is about. What do you investigate? Are you going to investigate whether that conclusion by the Constitutional Court constitutes a serious violation or a minor violation? What is it to investigate?
Yes.
What is there to investigate, rather?
Yes. Chief Justice, what I would submit with respect on this topic, so there could be a finding by the court that says the president has failed to uphold and defend the Constitution. And that may refer, for instance, to the presidential executive functions.
No, within the context of this case.
Yes, on the
and
facts of-
bearing in mind the history, the particular history of this case. We know the public protector investigated. We know the court pronounced itself in the manner I've just alluded to.
Yes.
What are you going to investigate?
Well, Chief Justice, we would submit that there is still a necessity for an inquiry in order to allow the president an opportunity to explain himself. At this point in time, for Parliament, sorry, Chief Justice. I
No.
want to make a
Wrap it
follow-up
up.
question.
Wrap it up.
Yeah.
But my curiosity is overflowing,
Yes,
so you'll bear with me.
No, I accept that. But I would say, Chief Justice, that at this point, who knows, the president might have, and I'm not speaking on behalf of the president, but the president might have an exculpation. But
that's for him to say.
yes,
You don't have to be imagining possible exculpations.
Yes.
You look at the history, you look at the findings and the remedial action of the public protector, you look at the Constitutional Court judgment.
yes,
What do you want to investigate?
yes. Chief Justice, I would,
On that score, confining ourselves to that. Put aside whether he told the truth about this or the other thing, whether he knew, whether he should have stopped, just on that.
Yes.
What do you want to investigate?
well, Chief Justice, I would still submit that it's still essential, firstly, to allow him an opportunity. The second,
So you are worried about his interests,
yes, well,
instead of allowing him to be worried about his own interests.
Chief Justice, it's, the difficulty, of course, is that the judgments cut across, future presidents as well. But I would be worried in endorsing an approach that would simply cut out the possibility of some form of Audi on his part.
Is that the reason? So what is it about this finding that you want him to possibly come up with an exculpatory explanation about?
Well, Chief Justice, there is an old judgment of the House of Lords, that sometimes a case may look open and shut, but when subjected to a hearing, an explanation emerges.
No. Here is a significant portion of the National Assembly in the form of the Economic Freedom Fighters, the Democratic Alliance, Congress of the People, and the United Democratic Movement.
Yes.
They have the benefit of the Public Protector's report and the benefit of a pronouncement by this court. So, what is there about all this to give them reason to say, no, we must investigate?
Yes.
We must investigate. We hear the court, but we must still invest. What is it?
Yes. Well, what we've said, Chief Justice, is that there are two
What
things.
uncertainty do you want to clarify?
Well, we've said there are two things in our heads of argument, in our papers. We've said there are two things that justify this preliminary inquiry. The first is a determination of the seriousness. And I take,
So you mean this may not be serious?
well, Chief Justice, it depends on what he knew at the time and what he says.
No. Confine it to the finding of the court, the conclusion by the court.
Yes, well,
Are you, at least the party you represent, does it say this is serious or this is not serious?
No, we say it is serious, Chief Justice. So that's quite clear.
So what do you want to investigate?
Well, Chief Justice, does he have an explanation or not? That's the full extent of the answer to that point.
Okay.
And then the second part, of course, that must be investigated. Did he mislead Parliament?
Okay, let's park it there. You know, in order to kill whatever it is you want to kill,
Yes.
you can shoot, you can use a traditional weapon, a knife, or something else. As I understand it, just using that metaphor, your client wants to kill the president's term of office. And that can be done either through a motion of no confidence or an impeachment process. Am I right?
Yes. Well, Chief Justice, on the first part, I mean, do they want to kill the president's term of office?
They want to have him removed.
Yes, I would say, Chief Justice, that at this point in time, what is before the court is the determination of this preliminary question.
No. You see, this is all about accountability, isn't it?
Yes.
Well, let's start at the beginning.
Yes.
When a series of questions were being put to the president
Yes.
about the Nkandla issue, pursuant to the Public Protector's report, and even pursuant to the Constitutional Court judgment, was it not in an endeavor to have him account?
Yes, it was.
Is it correct that it was done 27 times?
Yes, indeed.
Right. When the DA brought a motion for impeachment, which is the same thing you want done now, was it not based on the Public Protector's report and the Nkandla judgment?
Yes, it was. I mean, there is, of course, a slight nuance on the DA issue, but I don't want to interrupt the flow.
But was the Nkandla judgment and the Public Protector's report, were they not reflected on, were they not the basis, or at least the significant basis, for bringing that impeachment motion?
Yes, that's true, Chief Justice. I mean, the only nuance that we would put on that issue by the DA is that absent a thoroughgoing examination.
No, we'll get to the investigation. I just want to understand this properly.
Yes.
And were there inhibitions in relation to the debate that preceded the voting?
Well, Chief Justice, I would say that there is, of course, a major factual gap. I mean, the point is that one cannot debate the issue in a factual vacuum.
No. With the benefit of the Public Protector's voluminous report, findings and remedial action, and this court's judgment, the debate took place. Parties or members of the National Assembly participated in a debate believing that there was a basis for the impeachment of the president. Or did they not believe that there was a basis based on the report and the judgment?
Yes. No, I would accept that, Chief Justice, that when the debate took place, it took place on the basis of these, firstly, there was a judgment, and secondly, there was a report.
Exactly.
But what I would still add, Chief Justice, is that absent that inquiry...
No, we'll come to the inquiry.
Yes.
Because nobody stopped them from asking for the inquiry. They are part and parcel of the National Assembly. You can't talk about the National Assembly without including the EFF, the DA, UDM, and COPE. They are part and parcel of the National Assembly, inasmuch as all of my colleagues here are part and parcel of the Constitutional Court. You can't have from Justice Madlanga to Justice Katrisik Tiluali in relation to this matter, bring an application and say, yeah, Mogoeng is refusing to write a judgment. They are part and parcel of it. So let's deal with that. I think it is my brother Jafta, stand to be corrected, who said, had that motion succeeded, would we be here?
Well, Chief Justice, I would submit, I mean, it's the debate we had about if the motion of no confidence succeeded.
No. Impeachment. I'm at the impeachment level.
Yes. Well,
Had that motion last year already succeeded, would we be here?
yes. Well, I would submit, Chief Justice, what would have happened, of course, is that there would have been a major constitutional oversight because it would have happened in circumstances where there had been no Audi on the part of the president. And
No. How can there be no Audi? Had he not been asked questions before then?
Well, Chief Justice, it still remains the case, at least in our respectful submission.
So it would have been an unconstitutional impeachment.
Well, it's doubtful because that's what we say in our application. We say that because there had been no inquiry to establish the facts, because the Constitution says serious violation,
Yes.
and it cannot be assumed just because there is a
Okay.
judgment. In fact, I wanted to refer to a judgment made
No,
by
don't
you,
refer.
Chief Justice.
No, I'm fine. Anyway, refer, but come back to my point after referring.
Yes,
Had
because I
that
want to-
impeachment process succeeded, would we be here?
Well, I would submit that,
Because you would appreciate us judges, we just want to know the issues.
Yes.
And cut to the chase, that's it.
yes. Now, the one part I wanted to refer you to, Chief Justice, with respect, is a passage in the Nkandla judgment where the court debates the question what to do with the public protector's findings.
Yes.
And it debates in particular the reaction of the speaker. It finds in 2 lines that it was in fact obligatory on the speaker to satisfy themselves
Yes.
about the facts,
Sure.
and that it would have been unconstitutional for the speaker to just assume that those facts that have been found by the public protector are therefore sufficiently dispositive.
Yes.
And in fact, the next line coming from that passage says that even in relation to court judgments, I just want to make sure that I don't misinterpret the point. So what I would submit.
No, Justice Cameron is looking for his PA. His club.
No, I thought he was looking for me.
No. I'm the one looking for you.
So what I would submit in relation to this point is that it would not be consistent with the scheme that we are proposing.
That you are proposing, not that is in the Constitution.
No, we submit that the scheme that we are proposing is more consistent with the scheme of Section 89.
Yes.
A scheme that simply runs through Section 89 and then resolves the question by vote. What it ultimately produces
Yes.
is an outcome that ultimately detracts from the duty to scrutinize. The point I wanted to make about this passage is that even in circumstances where you had before you the findings by the public protector, you still said the National Assembly had to satisfy itself because it's performing a completely different function. You see, and this is the argument here. When the public protector is investigating what to do, she is discharging a responsibility under Section 181, and when the court had to decide the case, it was again discharging its judicial responsibility. The court was not deciding whether or not the president must be removed. It could not do so because the mandate is not of the judiciary to remove the president. When the matter goes to the National Assembly is discharging a different function. It is concerned with the accountability of the president. Obviously, it must take into account that there are findings made by the courts, and it must take into account that there are findings made by the public protector. But, Chief Justice, I submit with respect, it must still, in order to discharge its mandate properly, it must still satisfy itself about what are the correct facts, not whether or not the Constitutional Court was right or wrong, but what are the facts necessary for the discharge of its function? In other words, what are the facts necessary for holding the president accountable?
I'm not too sure I understand you, but let me give you another example. I'm going to give you an absurd example that makes the point.
I doubt it, Chief Justice.
Let us assume a court of law concludes that the president had in fact personally shot to death 3 people, convicts him of murder, and imposes life sentence Well, life sentence, no. A wholly suspended sentence on him. Or whatever sentence. No, a wholly suspended sentence.
Yes. But
No, just there. So the matter comes before Parliament.
yes.
He's not ordered to go to prison, so he's available to serve. He's not a member of Parliament, so you can't remove him on the basis that a member of Parliament is not permitted to be in Parliament if he or she has been convicted of a crime. Would the National Assembly investigate
Yes, Chief Justice.
whether
I
the
would-
court was correct or not?
No, I would say even in those cases, Chief Justice, that it would still be imperative for the National Assembly, because what it is doing, it's satisfying itself about a completely different exercise. It's satisfying itself on the existence of the jurisdictional facts for removal. It's not deciding whether the president was guilty of a crime. That decision has already been made. So I would submit that in relation even to that example, that is not an absurd example because it tests the principle.
It's not a serious violation of the law to kill a person.
No, it would still be a serious violation, but the National Assembly still, and it depends on also the nature, because there could be various ways of conducting an inquiry. And it also depends, some inquiries could in fact be truncated, and some inquiries would be the inquiry that I propose.
Yes.
And sometimes when they conduct an inquiry, all they will do is simply to look at the judgment and to
Yes.
simply to look at the public protector report and say, we've conducted an inquiry and we are satisfied. But one can never jump the step that the National Assembly must, in the exercise of its own constitutional obligation, satisfy itself that the requirements for a removal under Section 89 have been fulfilled.
All right. How many motions of no confidence have been debated and decided upon in relation to the same issue you would want the National Assembly to conduct an investigation about? How many?
Well, Chief Justice, there is not after the judgment of the Constitutional Court,
Yes.
because that's the correct time frame.
Yes.
There is not a single one.
Not even after the, let's do it in stages then. After the public protector's report,
Yes.
any motion of no confidence in the president in relation to the Nkandla issue?
Yes. I can actually look at the facts on this.
Otherwise, you can come back later about it. And after the judgment, you say none.
There is not one motion of no confidence related to this. What had happened after the judgment, three things happened. On the 3rd of April, the Speaker released a press statement. In the press statement, the EFF says she misled the nation because she said that the Constitutional Court had not made any findings that she has acted unconstitutionally. And that is an allegation that is not disputed. And then on the 5th of April, we've debated about those. The EFF, in its own initiative, made a proposal. The DA, on the 12th of April, on its own initiative, made a proposal. But there is no motion of no confidence that has been debated after the judgment of the Constitutional Court. So we'll say that if one starts counting from the day the Constitutional Court gave a judgment, not one.
There's never been a motion of no confidence that has anything to do with Nkandla.
Yes, Chief Justice, it's except, of course, we are excluding from the examination the DA proposal because...
The impeachment one?
Yes.
No, I'm talking Section 102.
No, Chief Justice.
There's never been.
What, in fact, we know happened is that there was a subsequent motion which was based on the cabinet reshuffle.
Yes. Now, the question and answer sessions, I suppose it would be your submission, did not adequately traverse the issues pertinent to Nkandla. That is why there is a need for the same National Assembly to investigate those issues.
Yes, Chief Justice, I would submit with respect that what we are asking for is this thoroughgoing examination.
I'm on thoroughgoing. So their questions did not go far enough. They were not deep enough. They were all shallow. Therefore, there is another process necessary.
Well, Chief Justice, yes. What I would submit is that on the proposals that we have made of a committee that's specifically designed to deal with this matter as the only mechanism, really, that can go into the heart of the problem, there has simply never been such a process.
Yes. Now, where do we get authority from for this process that you are proposing? I've seen a reference to Brazil, I've seen a reference to the United States of America and other jurisdictions. Where is it in our law where we can find this for the court to be able to say, here is an order that is in keeping with the way in which impeachment processes are supposed to be conducted in South Africa?
Yes. Chief Justice, you would have seen, of course, from our heads of argument that our submissions are focused specifically on our constitution and our jurisprudence.
Sure.
That, of course, doesn't mean
that's for other people. Yeah,
yes,
focus
yes,
on your own case. Then.
Yes. So what we do, and let's split the relief that we seek into two. The first being the declaratory order. So the declaratory order is typically a judicial function, and that declaratory order is simply aimed at clarifying that the inaction subsequent to the judgment of the Constitutional Court is a sufficient breach of the obligations of the National Assembly.
Maybe just there you'll come to the second leg. Who should act?
Well, we have submitted that if one looks at paragraph 10 as well as paragraph, I think it's 83 of the Ngcukaitobi judgment.
Yes.
The obligation rests with the National Assembly, and the head of the National Assembly is the Speaker.
Yes.
So we say that the primary obligation is that of the National Assembly, and the head of the National Assembly being the Speaker.
And your client is the National Assembly?
Well, you see, this is the point, Chief Justice.
It's not the opposition, it's the National Assembly, part and parcel of the National Assembly.
Yes, indeed, they are. The point about this argument, Chief Justice, is that it's inappropriate for the representative of the National Assembly, that is the Speaker, essentially to subdivide the function into a constituent part of the National Assembly when she is, in fact, the constitutionally appointed body that is responsible for this. And one of the interesting bits about this is that if one looks at the proposals that are currently serving before the National Assembly right now, LT5 to the current answering affidavit, it is envisaged that the Speaker must decide whether there is a prima facie case of an impeachable offense under Section 89. Their own proposals contemplate precisely what we are asking for.
Let's deal with what we have. Let's forget about something that may or not be or may not become the rules.
Yes.
Every member of the National Assembly has an obligation to ensure that the executive is held accountable.
Yes.
It is not the sole responsibility of any party or the Speaker. Am I right?
Well, Chief Justice, I would say that there is a specific obligation on the head of the Assembly.
What about the obligations of individual members of the Assembly or members of the National Assembly as a collective to make sure that they run their own affairs in line with Section 57 and not have others do what they are supposed to do for them?
Yes, we would accept that entirely, because even our own proposal doesn't detract from that, because we accept that the accountability holding mechanisms must be established by the National Assembly.
Why don't you go to the Speaker, since she has rejected the proposal about judges having to be involved, and say, Speaker, you know, the SABC process was actually wonderful. I see that it's in some of your documents. It was wonderful. We abandoned that one that has failed about judges getting involved. In fact, we can run our own show. We propose an ad hoc committee.
Well,
assuming that there hasn't been a thoroughgoing investigation. Why don't you do that?
Yes. Chief Justice, let me...
Why should the court be the one to do it?
Well, firstly, on the first part of the declaratory order, that issue is not implicated at all.
Yes.
Because the declaratory order focuses on what has happened so far and simply determines whether or not what has happened so far is constitutionally sufficient or not. The second part...
No. Which is what?
Well, what has happened so far, in other words, whether the conduct of the Speaker so far has been such that it breaches the constitutional obligations.
Is it open to a member of the, or a portion of the National Assembly to come and say that?
Yes, well,
when they are not forbidden
yes,
from doing what needs to be done to kickstart that process?
What I do submit, Chief Justice, is that what has actually happened so far is more than adequate.
Yes.
The proposal by the DA was sufficient. The proposal by the EFF, if looked in good faith, and if
Yes.
looked at the substance, was more than adequate. And that's why we're entitled to the declaratory order.
Yes.
The question really arises in relation to paragraphs 5 and 6, which is the mandatory order. Should the court order the constitution of the ad hoc subcommittee that we are asking for? Or should the court, as the Speaker now says, refer the matter back to the Speaker for her own decision? But I would submit that, unlike in the secret ballot case, what we have here illustrates that, in fact, the court can step in at this stage because two motions have been brought. A specific motion by the EFF has been brought, asking for an investigation, which has
Last
been
year,
Yes, it was brought. last year.
April,
Yes.
over a year later, you come and say we must remember this is urgent in nature.
Well, Chief Justice, we brought the application sometime this year, I think in March.
Yes, almost a year.
Yes, but you recall, Chief Justice, that in September, there was a further reminder on the 12th of September by Mr. Shivambu. There was a further reminder to the Speaker. But,
How many months since a reminder of what? Was an answer not received yet?
yes, well, the answer was received on the 12th of May.
So?
The reminder about what the EFF's demand is.
Yes.
And Chief Justice, the point I suppose to make, the more important point to make really, not to get tied down into the minutiae.
Yes.
The important point to make is that the obligation started when the judgment certainly was triggered when the court delivered this judgment.
Yes.
When we speak today, that obligation has still not been fulfilled. It is of paramount importance, even if not urgency, it is of paramount importance that the National Assembly subjects the President to a proper system of accountability. The mere fact that there has been a passage of time compounds the problem. It does not exculpate him. It just makes it worse.
What does it stop the EFF or any party represented in Parliament, as has been the case with motions of no confidence, to again approach the Speaker and say, you know, Speaker, I know we've had an impeachment debate. We want you to set up an ad hoc committee, or we've done our investigation. We now want another debate on impeachment now that we have familiarized ourselves properly with the issues. Does that stop any of the members of the National Assembly from doing that?
Yes. Well, Chief Justice, I mean, had the EFF not made the request and then sent the reminder, the answer would have been, of course, we have not been. What we do know is that the Speaker has refused to conduct this inquiry.
Yes.
I mean, it's not as if there has been no attempt to make the request. It has been made and refused.
For what it is worth, let me explain my difficulty to you, Mr. Ngcukaitobi. You know, we are three arms of the state,
Yes.
and we each have a role to play in making our constitutional democracy function and function well. I just want to make sure that I understand the issue so well that this court doesn't get to the point where it takes over the responsibility of the National Assembly to the point of saying, establish this kind of investigative structure, and these are the terms of reference. Because once we make that order, they are not the terms of reference coming from members of the National Assembly. They are the court-prescribed terms of reference. I just have a discomfort. That's why I just want to make sure that I understand what you are saying and what the basis for that are.
Yes. Well, Chief Justice, could I make the following suggestion in relation to this point? I've already explained that paragraphs 2 to 4 of our notice of motion is a declaratory order. That is the function of the court. There can be no separation of powers debate there. The court could issue that declaratory order and simply not give paragraphs 5 and 6 if there is a concern about separation of powers. But it is still my submission that in this case, where there is in fact no dispute, and we appreciate the concern about separation of powers, but in this case, where there is no dispute about the propriety of the suggestion that we make, there should be no reason why the court should be concerned.
No dispute between who and who?
Between us and the Speaker.
Well, maybe you must go home and then sort out your issues. Rather than drag the court into what you are agreed on.
No, this is the problem exactly, is that if they themselves in their own affidavit say that they don't see a problem with the order they seek, that we seek, why don't they just concede it?
Well, why didn't, maybe it shows that you didn't discuss the issues, your internal issues,
Yes.
as thoroughly as you should have.
Yes.
You chose to come to court.
Yes. Well, Chief Justice, I mean, I've made the submission that,
Yes.
that once we made our request
Yes.
and it was refused, we were then entitled to come to court.
Let me ask this question, Mr. Ngcukaitobi. If we arrive at the conclusion that, that the decision of this court in Nkandla can only lead to the conclusion that the president had committed a serious violation of the Constitution or the law, would it still be open to us to order the investigation you have in mind? If we arrive at the conclusion that the only way, the proper meaning of our decision, assuming that we were ever to come to that conclusion, is that that constitutes a serious violation of the Constitution or the law, would there still be any room for saying, no, go and investigate, and these are the terms of reference? We just want to make sure that the president is treated fairly. That's you know, he must be given the opportunity to answer.
Yes. Well, Chief Justice, I would submit that the finding that there has been seriousness, again, does not displace the obligation on the National Assembly to consider, this is what we propose, to consider what this means for the Section 89 process. So if a judgment came from the court, probably, I mean, on the terms that, as I understand, are being proposed by the Chief Justice, we don't want to tie the hands of the National Assembly. It must still exercise its constitutional function. Because there are two things that appear from Section 89. The one is may, which is discretionary. In other words, the mere existence of those requirements is itself not dispositive. But even the very question whether those requirements, A and B, exist, it's something that the National Assembly must itself decide for its own purposes.
Okay, let me put it this way. Do you know of a party in Parliament that believes, in the National Assembly that believes, based on the debates around the impeachment process, based on the question and answer sessions relating to the Nkandla matter, that believes that the decision of this court in the Nkandla matter does not justify a conclusion that there has been a serious violation of the Constitution or the law?
Well,
do you know of any? Because somebody must be doubting that for an investigation to be necessary.
Well, Chief Justice, it's clearly possible that there are
No. Do you know of any?
Well, there is nothing on these papers before us.
Does your client doubt?
Yes, of course, my client is quite clear on the matter.
So, what does your client want to investigate?
Well, this is the point, is that ultimately there has to be an establishment of whether there is a prima facie case under Section 89. That is what we've come to court to ask for. So, if you look at the terms of reference we've proposed, does the conduct of the president lead to the conclusion that he is prima facie guilty of an impeachable offense? That question also depends on what he has to say, Chief Justice. And it does not depend only on what the court has to say. We would say that
it depends on what Parliament, what the National Assembly makes of what transpired, makes of his conduct. That's it.
Yes, Chief Justice, but I would still say that it also depends in part on how they treat his own evidence before them.
If one ground is good enough, do you need to explore many other possible grounds, like whether he lied, whether he knew, and so on?
Well, on what we have proposed...
I just want to understand the premise from which EFF and I'll deal with other parties. The basis, the premise from which it moves.
Yeah. On what we have suggested, Chief Justice,
Yes.
both grounds, because both grounds are in fact interlinked, because the reason he misled Parliament in our submission
Yeah.
had to do with the very issue about whether or not he enriched himself at the expense of the nation.
No, that I understand. I want to, I reflect on the judgment for myself, I want to know, does your client, the EFF, have a doubt about whether the President's conduct, in view of the Public Protector's report and this court's judgment, amounts to a serious violation of the Constitution or the law? Does it have a doubt
No, Chief Justice,
on that point alone?
we don't have a doubt. It's clear to us. That's what we say in our
So you
paper.
don't want any investigation on that point?
Well, Chief Justice, what we do want an investigation on is what does he have to say for himself?
Okay.
And we also want an investigation into, did he lie to Parliament or not?
Yes. Okay.
And that has been no finding by this court on that
Sure.
issue.
Sure.
But, Chief Justice, that does not detract from the seriousness of the conduct. I mean, I don't want to leave the court with the impression that we don't think that the findings made by this court are serious.
Yes.
It is precisely because we think the findings made by the court are serious that we say that the President must be subjected to a thoroughgoing investigation so that he can explain himself.
Yes. Well, I think I must thank you.
Thank you, Chief Justice.
Thank you, Mr. Ngcukaitobi. The court will take a break for about 15 minutes.